You speak English, sir?
Yes, sir.
Good morning, gentlemen.
Morning.
How's jail?
Ain't fun.
Good. It's not supposed to be fun.
I'm disappointed. I wasn't even supposed to be there.
Let's talk. We'll figure out why. All right. Both of you guys have picked up criminal cases. You've not made bond, and you don't have anyone that's going to make a bond for you. That's why you're in there right now. Your lawyer is asking for me to give you either a PR bond or to lower your bond. And we're going to have a discussion now as to whether that's going to happen or not. I'm a firm believer that everybody should be given at least one chance to see whether they're going to do right or not. Right? So hold on. Just don't say anything yet. You'll get your chance. I promise. Mr. Guerrero, let's start with you. So you're charged with terroristic threat. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On January 27, 2025, at 8:11 a.m., the officers arrived on the scene for a weapons disturbance at a residence in Harris County, Texas. The officers met with the complainant and a witness outside the residence and later met with the defendant inside the residence. The complainant stated the defendant, the ex-husband, lives with her at the house since last year. The complainant stated the defendant has threatened her numerous times and she was scared of what the defendant would do if she called the police. And on November 3rd, 2024, the defendant texted the complainant, I didn't put I'm fucking you up when you come back, bitch, but never assaulted the complainant. And in the middle of December 2024, the complainant was on the phone talking with a friend when the defendant approached the complainant from behind and tried to take her phone and shouted, asking who she was on the phone with. The defendant failed to get the phone away from the complainant. The complainant ran out of the residence out of fear. Around Christmas 2024 at approximately 7 to 8 p.m., the complainant and the defendant were arguing about the complainant's boyfriend having a key to her vehicle. The complainant and the defendant went to go get the keys and the defendant stated, I'm going to kill him. The complainant was in fear and the complainant's boyfriend did not want police called. On January 26, 2025, the defendant came out of his room and the complainant's jacket on the chair where the defendant's cane normally rests, and the defendant saw his cane laying on the floor, and the defendant accused the complainant of placing it there. The defendant followed the complainant into the kitchen and was close to her face. The defendant told her, you know I could hit you with this cane. I can hit you with this. Next time I will hit you. The defendant was waving the cane in her face as he said this, and the complainant was in fear of what the defendant may do to her. The defendant calmed down, so the complainant did not call the police. The complainant called the police the next morning because she wanted him out of the house. The witness, the son, corroborated the complainant's telling of events and stated the defendant said to the complainant, I could hit you if I want to, and was close to the complainant in the hallway and was waving the cane in the complainant's face.
Guerrero, I'm going to find that there's probable cause to go forward with your case. The magistrate here did not give you a PR bond. If I give you a PR bond, I want assurances that you're not going to have contact with the complaining witness in this case. You're not going to have.
Daughter, she's gonna take me somewhere else.
That's it. 95% of the people that are in jail now because they have no self-control. They get upset and they wig out and do whatever they, without thinking, if I do this, what's going to happen? If I say this, what's going to happen? Would you like me to give you a PR bond?
Yes, sir.
I don't want you to have contact with the complaining witness in the case, sir. I don't want you to have any weapons, and I want you to have self-control. I've given you a lawyer. It is your responsibility to stay in touch with her. I'm giving you a chance now.
Yes, sir.
Don't pick up any new cases and don't disappoint us.
No, sir.
You understand?
Yes, sir, I understand.
Do you mind filing those conditions that he's not to have contact with this person?
No weapons, Your Honor, as well.
No weapons, no contact. I am also entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Cortez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir, I understand.
If you have kids and they live with her, then use someone else. Don't call, don't go over there because you now know no one's going to bond you out. So if you end up going back to jail, you'll be stuck like Chuck.
Yes, sir.
You understand?
Yes, sir.
All right, man, I'm giving you a chance.
Okay.
Okay. So please, if you can still file those conditions, no contact, no weapons. Now, Mr. Ellis, your case is quite a bit more complicated. You were charged with unlawful carrying of a weapon. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 29th, 2025, at approximately 3:29 p.m., the officer dispatched to a weapons disturbance call at 5900 Long Drive in Harris County, Texas. The officers were given a description of the defendant and that he was dancing, waving a gun. The officer arrived at the location and saw the defendant matching the description at a bus stop. The officers observed the handgun sticking out of the defendant's front right pocket, and the officers told the defendant to put his hands up, and the defendant continuously refused orders from the officers to let go of the firearm. The officers used force and pulled the defendant's arms away, and the defendant continued to grip the firearm, attempting to pull it out of his pocket. The officer was hit by the defendant while pulling away, and the officer was thrown into a metal and glass wall at a bus stop. The officer sustained minor abrasions to his right arm, and the officer struggled with the defendant for approximately 6 minutes until detaining him. The officer spoke with a witness who stated she was walking to work and heard and saw the defendant dancing and rapping while waving around a firearm multiple times.
Mr. Ellis, let me read something to you. This is why the magistrate did not give you a PR bond in this case. Defendant on a 3-year deferred for a state jail felony since 3/21/24 allegedly stole CBD disposables. In this case, the witness called to report a man dancing around and waving a firearm in the air at the 5900 Long Drive in Houston, Texas. Law enforcement officers arrived, saw defendant matching the description as sitting at a bus stop, saw butt of gun sticking out of his pocket. Law enforcement officers told defendant to put his hands up. Defendant instead reached for his gun. Do you know how many people die from that very thing right there? Watch the news every single day in America. A young person dies just because of that very thing right there. Law enforcement officers struggled with the defendant as he continued to reach for the firearm, finally got him cuffed after approximately 6 minutes, then recovered a loaded .45 pistol from his pocket. One law enforcement officer injured during the struggle, pushed against the wall of the bus stop, sustained minor abrasions. Could have been another assault of a peace officer, which is a 3rd-degree felony, 2 to 10 in the penitentiary right there. Witness identified defendant as a person she saw dancing, rapping, pulling out a black pistol from his pants and waving it around multiple times, not obeying NFC of the deferred, the conditions of the deferred. Public safety concerns, indigent per AFC. This is the reason why you were not given a PR bond in this case. And quite frankly, Mr. Ellis, it scares me that if we let you out, what's going to happen? Sometimes we have to protect people from themselves because of their own worst enemy. Counsel, what would you like?
I would like to get his bond lowered. He is staying with his mother. His mother will be able to, keep an eye out on him and make sure that he does abide by the conditions that was previously set. I will give her a call today. He's looking for work and he has a child on the way. We're just asking for a lower bond.
What do you do with yourself these days, Mr. Ellis?
I'm just looking for a job so I could take care of my family because right now I'm with a whole 36-year-old and I'm 20 years old and I'm taking care of her kids, her and myself. And I'm staying with my mom and I'm in and out with my baby. So it's a whole lot of stuff going on. And then even dealing with that 3rd-degree felony.
It's not, I don't want to talk about the cases. My concern is that, Mr. Ellis, you're a baby yourself and now you got a kid on the way. How many kids you got?
This will be my first, because I lost my first son at the age of 15, stillborn.
You were 15 when you had your first kid?
I will make contact with his mother, Your Honor, before I leave today. She's present in his life. Yeah.
What's going on with the deferred upstairs? Have they done anything? Have they filed a motion to revoke?
Let me see. It does not appear that this time they filed a motion.
What do you guys think as far as a bond reduction? State.
Your Honor, based on the fact of the nature of him being a threat to the community and to the officer themselves, which are considered under 1750, and we request 5,000 would be.
I'm requesting 2,500, Judge. He's out of work, and the person that would make bond for him would be his mother. And
How long has he been on probation? He's been on probation for a year. Let me see how well he's done. He's already had one BVR. You know, when you're on felony probation, you're supposed to live like you have a halo above your head because you're really looking at a lot of time in prison. And the way things are going now, this is not a good way to go. You're going to end up either dead in prison. It's hard enough in this society as a black or brown person. All you're doing is making it more difficult. The older you get, the more difficult life gets. And if you don't have a skill, a trade, knowledge, you're going to end up with a 40-year sentence or in a gutter, begging, because life sucks without money. And what you're doing now, all you're doing is you're making life even just the more difficult as it is. The more convictions you get, the more unemployable you get. If you don't believe me, when you go back there in the pods, ask. All the old timers that are in there, ask. You're 20. Don't squander your opportunity. I'll give you a bond reduction. I'll set it to 10,000 now.
okay.
I'd like to have contact with mom. So
Okay.
somehow if you can like arrange so we can figure out how we can get through to Mr. Ellis.
Yes.
So what we can do to, I'm not opposed to a PR bond,
Okay.
but I want to know that somehow we have some kind of structure in place so that we know.
Okay, Judge. I will call her today. How would you like me to get back in contact?
I'm assuming he might go to felony court Monday. We can roll it to Monday
Okay.
and then just stay in the loop with me and then
Will do.
we'll structure things so that we can try to get him on the up and up.
Okay. Thank you, Judge.
I'm not going to let you die here. I'm not going to let you squander this opportunity. I will stay on top of this until we get you going well, because the way that you're going now, it sucks. It's not good. You're not to use any weed. You're not to use any alcohol. And I'm going to stay on top to make sure. I'm giving you a curfew. I'm going to do all these conditions to make sure you're not going to end up another statistic. Do you understand? So we're going to roll your case to Monday because I want to see if we can get your mom involved in this, see where we can go. Okay? All right.
Thank you, Judge.
Thanks.
The pure bonds.
No, yeah, PR bond on Guerrero and then 10G on Mr. Holtz. Now stand charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are in a dating relationship, and on January 25th, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated that he and the defendant are dating and that they had recently gotten into an argument earlier that day. The complainant stated that he had thrown some nicotine cartridges on the floor and that the defendant and him got into a physical altercation but separated. The complainant then made food and brought the defendant a plate of food, but the defendant used it to strike the complainant in the face, causing a laceration above his eye. The complainant then stated that he began to fight back.
Same complaining witness in the terroristic threat?
No, sir, Your Honor, it's not.
No, Your Honor. It does appear that the complaining witness in the recent assault was a witness to the previous terroristic threat, but I'm still not sure the involvement so far.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
Yes, sir.
I asked you one thing. I asked you not to pick up any new cases. You have done, because you have done this now, I'm going to revoke your bond on your first case, and I'm going to put you in jail right now. Goes with you, officer.
Thank you, Your Honor.
Thank you, Mr. Dean. Mr. Rodriguez, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes. On January 23rd, 2025, the officer observed a black Silverado and a white Honda Accord at the 7800 block of South Highway 6, turning left at a high rate of speed. The officer made a U-turn at the intersection to follow both vehicles and had to travel approximately 66 miles per hour in a 40-mile-per-hour zone. The officer observed the motor vehicles to be side by side, with the Honda flashing its emergency lights. The officer observed the Honda turn off the lights and both vehicles began to speed up again, driving side by side. Both vehicles ran a red light and the officer attempted to catch up to both vehicles, traveling approximately 90 miles per hour in a 40-mile-per-hour zone. The officer briefly lost sight and re-observed the Silverado as the motor vehicle continued traveling eastbound. A traffic stop was initiated and the officer made contact with the defendant, the driver, and sole occupant. The defendant stated, when asked about the high rate of speed, "No, I was on my way home with my friend Adam. Adam was following me home." The co-defendant then arrived, claiming he was there to check on the welfare of the defendant, and the co-defendant stated, "I was following him home, but I broke it off because I wanted to get something to eat."
Sir, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to participate in these types of activities again. If I find that you do, I'm going to take your privilege to drive away from you. Do you understand?
Yes, Your Honor.
Living in a city as big as Houston without the ability to drive sucks really, really bad. Do you understand?
Yes, Your
All I'm asking you to do is don't race, no reckless driving, street takeovers, donuts, anything of this nature. Do you understand?
Yes, Your Honor.
There are proper places in Houston to do it, not on 610 or 59. Can you file those conditions, please? All right. Now, you have a great lawyer. Listen, Mr. Petoniak, he will help you out. Because you have him, I will waive your appearance. You don't have to waste your time coming to court, but stay in touch with him. He'll tell you when you have to come back to court.
Yes, Your Honor.
For now, we'll just have you sign a reset. We'll have you take a seat in the jury box. We get your bond conditions. We'll have you sign it. And after that, you'll be free to go. All right?
All right, thank you, Judge.
Sir, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge.
Okay.
On January 26, 2025, at approximately 12:31 a.m., the officer observed the vehicle on East Sam Houston Parkway turn southbound in front of the officer, making a wide right turn and entering his lane of travel, forcing him to slow to avoid a potential collision. The officer observed the vehicle swaying within its lane and within the vicinity of another motorist. The vehicle accelerated to a high rate of speed of 61 miles per hour in a 45-mile-per-hour zone, and a traffic stop was then initiated. The officer made contact with the defendant and observed glossy eyes, slurred speech, and odor of an alcoholic beverage. The defendant stated he was coming from a party where he had 2 shots and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 3 out of 8, one leg stand 2 out of 4. The DIC was read and the defendant refused to provide a breath specimen, and an inventory search was conducted and the officer found 2 Modelo's cold to the touch and mostly empty and 1 pint of vodka. The passenger advised the vodka was hers and the beers were the defendant's. Blood search warrant was signed and executed.
Are you drinking while driving?
Yes, Judge, cold to the touch.
Mr. Escobedo, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm now also ordering you not to drive at all. Do you understand?
Sir.
You will be signing an affidavit with me today promising you're not going to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. I don't care what your excuse is. Do you understand?
Sir.
I would think that it's elementary that you're not to have alcohol in the car while you are driving. If I find that you pick up a new case, you become a danger to my city, you consume alcohol or you drive, I will revoke your bond, put you in jail, no more PR bonds for you. Do you understand?
Your Honor, made for my client. My client is 19 years old, Your Honor. I've known him for a long time. I know his family, and he works at the refineries right now. It would be onerous on him to not be able to drive, and Your Honor, my client would be requesting if maybe there was some alternative, potentially,
Defendant Escabo faced DWI charges after refusing a breath test and driving with alcohol in the car. The judge ordered no alcohol, no drugs, and no driving, warning any violation would mean jail. Despite his attorney's plea for leniency, the judge emphasized the privilege of driving and demanded complete compliance.
a machine in the car to make sure that he's.
You know, I mean, he's 19. There's alleged 2 cold beers he's drinking while he's driving. No. I want you to appreciate the absolute privilege it is to drive. It's not a right. You want a right, take your Dutch patas and you can do that. No. If after a while you can show me that he appreciates it proactively, right? And I get it, then we can talk. But until that point, I don't care what you're doing. I don't care if there's a burning building, you have to save 50 children. You drive. It's really not going to go well for you. Do you understand? It's not set in stone, but I want to know that he's not taking it for granted anymore and that he absolutely appreciates it. And I think that living in a city as big as Houston without the ability to drive blows, and we'll see whether you actually see it or not. Don't drive. I'm absolutely serious. Do you understand?
Yes, Your Honor.
Now, because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Casanova and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, you've gone AWOL, pick up a new case, become a danger, I will issue a warrant for arrest. I'm going to put you in jail and that's it. You understand? You're in good hands with Mr. Casanova. He'll treat you well. Just listen to him and he'll take care of you. I'm going to have you come up here, swear test if you're not going to drive. I'll get you to Victoria Sign and Reset. You'll get with, is it Vanessa? What is it? Fatima. Okay, so we have now Fatima with pretrial services. You'll get with her. And then after that, you guys are free to go. Okay.
Thanks, Judge. Appreciate you.
Thanks. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The complainant is the defendant's stepson, and on January 25th, 2025, the officers were dispatched to a family disturbance in Harris County, Texas. Upon arrival, the officer met with the defendant, who stated that he and the complainant were in a verbal argument that turned physical. The defendant stated he attempted to forcefully remove the complainant from the bathroom and then got into a fight. The officer met with the complainant, who stated that the defendant and him got into an argument over a key to the shed, and that the defendant went into the bathroom and started striking him in the face with a closed fist, causing pain. The officer observed small lacerations on the complainant's head and face, and the officer spoke with a witness who stated that she observed the defendant on top of the complainant striking at his head.
What is the relation?
The relation is the complainant is the stepson of the defendant.
Stepson. Okay, do you know the age?
The age is, one moment, Your Honor.
Do we know whether he wants to have contact with Mr. Wong?
So we haven't had a chance to reach out, or we tried, but we had no success. And then the age of the complainant is 47.
Okay, so Mr. Wong, I'm going to find that there's probable cause to go forward with your case. There is a protective order that has been issued in this case. I would get to know it. If you do something to violate this protective order, the state can and probably will file additional charges of violation of the protective order, and it's one of the worst cases that you can pick up here. I am ordering you as a condition of your bond not to have any contact with this person. I want to know what their wishes are if they want to have contact with you, and we just don't know whether they want to or not. So until we know, you're not to have contact with this person and not to be in possession of weapons. Do you understand? If you violate these conditions, if you pick up a new case, then I'm going to issue a warrant for your arrest, put you in jail. No more PR bonds for you. Do you understand?
Yes, sir.
Good job on having a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her and she'll tell you when you have to come back to court. For now, I'm going to have you just sign a receipt, Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay?
Judge, does that protective order just cover the complaining witness and not the witness? Because I think.
It covers, let me see.
Sure.
It covers the South Champagne Circle in Tomball,
Oh, just the address.
that address.
Okay.
Do you live at that address?
Yes, sir. Mortgage on home.
Who own, so get with them because I don't know how that's going to work out because they've not been able to rip and I don't know if the other person has a right to be there as well. If they cohabitate, they share it. It's going to be a problem. So we're just, We'll have you guys work out the kinks and then just let me know.
Okay.
Okay. Wait, hold on. We'll have you sign a reset
I have
first.
one more, so.
It's okay.
Right this way.
Jose Ernesto Mejia Hernandez.
Sir.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On January 26th, the officers were dispatched to an accident at 2200 West Sam Houston Parkway North. Officers observed a green neon vehicle with front end damage on the shoulder of the road. Officers made contact with the driver, who appeared to have glossy eyes and slurred speech. After relocating to a gas station, the defendant stated he was returning from his girlfriend's house. Defendant stated that he had 2 Modelos, but did not know the size of them. SFSTs were conducted, 6 out of 6 on the HGN, 4 out of 8 on the walk and turn, 3 out of 4 on the one-leg stand. The ICs were read, breath test performed, and he blew .094. And there is criminal history, reckless driving, 2016.
Any other prior DWIs?
No, Your Honor.
Can you run his license, please? Mr. Mejia Hernandez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I'm going to revoke your bond, put you in jail. You understand?
Sir.
And he does have some bit of a driving record as well.
Does he have a valid one? No?
I believe so. No, where's?
It's eligible, Your Honor.
You are not allowed to drive unless you also have car insurance as well. Do you understand? You need a Texas driver license and liability insurance in your name. If you don't, then you're not allowed to drive. That is a bond condition of yours as well. Do you understand?
Sir.
Now, you have a lawyer. I will waive your appearance, but you must stand justice. She'll tell you when you have to come back to court. For now, I'll have you sign a receipt of Victoria. We'll have you get with Fatima for your bond conditions, and after that, you guys are free to go. All right? Okay, please. Thanks. Sir, you were charged with driving while intoxicated. You were facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
Yes, Judge. On January 25th, 2025, at approximately 4:44 p.m., the officer was conducting a city ordinance enforcement at Metro Mart convenience store. The officer observed a vehicle reverse into his patrol vehicle in the back left quarter panel. Minor damage was observed, and the officer made contact with the defendant, the driver of the vehicle. Another officer arrived on scene and observed the defendant to have glossy eyes. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 2 out of 8, and one leg stand 2 out of 4. The DIC was read and the defendant consented to breath. The results were .112 and .112.
Any prior DWIs?
No, Your Honor.
License?
No license, Your Honor.
Mr. Guevara, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive. If you do not have a Texas driver license and liability insurance, you are ordered not to drive. I don't know what your immigration status is, but if you were not in this country with permission and you go to jail for any kind of extended period of time, immigration will put a detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you will be shipped off to immigration. I'm putting bond conditions on you now. If you violate these conditions, I'm going to put you in jail. And if you're unlucky enough, you're going to be there for an extremely long time. Do you understand? You are not to consume alcohol, illegal drugs. You will be randomly tested. If you fail to go test, I will issue a warrant for your arrest. If I find that you're driving in violation of these conditions, likewise, you will go to jail. Now, you have a lawyer. It is your responsibility to stay in touch with counsel. He will tell you when you have to come back to court. If he tells you that he can't get a hold of you because you're not responding to phone calls, text messages, likewise, I will issue a warrant for your arrest.
Voy a poner orden de aprehensión igualmente. Okay.
For now, I'm going to have you sign a promise with us that you're not going to drive. After that, I will get you to Victoria where you will sign a reset. You will then get with Fatima for your bond conditions, and after that, you're free to go.
Thank you, Judge.
Good morning, Mr. Rodriguez.
Sir.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
On waive probable cause.
Do you have a Texas driver license?
I'll run it, Your Honor.
And any prior DWIs?
California. He has California driver's license, Your Honor.
I guess any prior DWIs would be the
There you go.
appropriate question.
Hey, I'll just run an NCIC, Your Honor, because I see no driver's license on our system, but I'll try to run that again as well.
He recently moved here from California, Your Honor, with a California driver's license.
And I'm assuming that you're going to do the ALR and all the jazz.
Yes, sir.
So I trust you, Doug. So since you're waiving PC, I'm still going to find probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, a warrant for your arrest will be issued. You will go to jail. If you pick up any other new cases, likewise, I'm going to revoke your bond, put you in jail. As long as you have a valid license to drive and liability insurance, you may drive, and he will tell you if it does become suspended. If it does, at that point, you may not drive. No prior DWIs?
No prior.
All right, so you have a lawyer. I will waive your appearance because you have a lawyer. You don't have to waste your time coming to court, but just stay in touch with Doug and he'll tell you when you have to come back to court.
Thank you.
All right? Okay, guys. Have you signed a reset? We'll go with pre-trial and then you guys are free to go.
Yes, thank you very much.
Happy Friday. Mr. Bob, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 24th, 2025, at 10:13 p.m., officers were dispatched to a major crash on Irving Boulevard in Harris County, Texas. The defendant ran a red light and another vehicle struck the back left rear of his vehicle, and officers arrived on scene and saw the defendant sitting in the driver's seat with keys in his pocket and the engine running. The officer observed the defendant to be unsteady on his feet with an odor of an alcoholic beverage. The officer then observed the defendant to be unsteady on his feet and needing help walking at times. Furthermore, they observed red glossy eyes, slurred speech, and a strong odor of an alcoholic beverage. The defendant stated he was coming from a club and was heading home. The defendant stated he had 3 to 4 drinks, and standard field sobriety were then conducted. HGM 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. A search was conducted on the defendant's vehicle, and the officers found a 1/5 full bottle of whiskey in the passenger seat in a bag, and the defendant consented to breath, and the results were 0.175 and 0.162.
Are you telling me that he's consuming alcohol allegedly while driving?
There's no indication of being cold to the touch or anything, just 1/5 full on the passenger seat.
What was it?
A bottle of whiskey.
Right. Mr. Bob, I'm going to find that there's probable cause to go forward with your case. Can you run his license, please?
It's eligible, Your Honor.
I'm ordering you as a condition of your bond and not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming illegal drugs or any kind of alcohol, I will put you in jail. Because it's a second offense, I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I'm going to put you in jail. Do you understand? I'm sending notice to DPS in Austin where every single officer now knows that any vehicle that you drive is required to have an interlock. So if you're pulled over and it doesn't have an interlock on it, then they're going to take you to jail. Do you understand? Okay, please. Yes. I'm sorry? 7.
My counsel didn't show up. I don't know.
You have a lawyer?
Yeah, I do, but he didn't show up. George Powell.
Oh, well, let's do this. I didn't realize it. So let's do this. I'll have you sign a reset. We'll have you get with Preachal for your bunk and just hang tight. He'll be here. I mean, we start early and I don't know. Don't fret. I'm sure that he's on the way. Okay. I know George. He's a good guy. We'll just have you take a seat after you sign both your conditions and then we'll wait for him to come. Okay? please. All right, Mr. Diaz, I don't know why we have you in custody. Well, I'll tell you now.
Yes, sir.
You, with us, have picked up a possession of a controlled substance. You are facing up to a year in jail and or a $4,000 fine. What I see is that you are now also on felony probation for possession of a controlled substance. It looks like they've issued a warrant. You're set at no bond on that case. So we have to take you into custody. I can't let you go with a felony warrant. So what'll happen is you will probably roll up on Monday's docket in felony court, and then, assuming you have a lawyer, they'll help you out upstairs. So regardless, we're going to do probable cause in our case. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I will also appoint you a lawyer this morning.
Yes, sir. I just got done talking to my, he's on his way actually.
Who's your lawyer?
Robert Reyes. I just got done there talking to him before he pulled me in the room.
Okay, we're gonna do probable cause, and then I'll just have you in back. When we get to any issues, we can always talk.
Okay, thank you.
Please.
Yes, Judge. On January 25th, 2025, at approximately 1:18 PM, the officer was dispatched to Katy City Park in Harris County, Texas, in regards to a male drinking in public. Dispatch notes described a Hispanic male wearing black pants and a black and gold jacket. Upon arrival, the officers observed a person matching that description walking away from a field where the suspect was reported being suspicious. The officers met with a witness who observed the defendant walking towards the parking lot and west of the field, and then the officer made contact with the defendant and observed him appearing intoxicated, slurred speech, incoherent speech, unsteady without the ability to stand, and the defendant was detained, and the defendant was uncooperative and made demands ensuring the officer of street accreditations, and a pat-down was then conducted. The defendant was in possession of an amoxicillin bottle with the defendant's name on it. The bottle contained illegal contents. In the bottle was a pinkish, orangey, unknown pill and a white pill. The white pill was recognized from training experience as Xanax with a weight of 0.29 grams.
What's he doing, walking while Hispanic, you know?
What?
Really?
Your Honor, there was a report of a person drinking in public, and then there was a witness who saw him walking to the parking lot, and then they gave a description, and he matched that description.
Let's do this. I'm not ready to roll on your case. Let's wait for your lawyer to get here. I'm gonna have him look at everything, and then we'll go from there. Do you mind?
All right.
Okay, you got it, man. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant and the defendant are roommates. On January 25th, 2025, the officers were dispatched to a disturbance call. Upon arrival, the officer met with the complainant, who stated that she and the defendants are roommates and that the defendant was crouching down with his phone when she touched his phone to indicate for him to move. The defendant then struck her in the face with a closed fist, causing pain and a small cut to her lip. The officer then observed a small cut to the complainant's lip.
Sir, I'm going to find that there's probable cause to go forward with your case. There's a protective order that has been issued in this case. I would get to know it. If you violate this protective order, they can file additional charges against you. A violation of protective order is one of the worst cases you can pick up. Do we know if she wants to have contact with him, Alex?
He attempted to reach out, but no success.
Until I know that she wants to have contact with you, I'm ordering you not to have contact with her. You're not to be in possession of weapons as well. Do you understand? If you violate these conditions, I'm going to issue a warrant for your arrest. I'm going to put you in jail. No more PR bonds. Would you like a lawyer, sir? I need you to fill out an application for me. I'll have you talk to someone today. I'm going to have bond conditions created for you to sign. Do not leave until you sign the bond conditions. Otherwise, I'm going to issue a warrant for arrest. We'll provide you a lawyer today. All right? Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause.
Defendant Miss Orange was charged with driving with a suspended license. The judge strictly forbade her from driving until she restored her license and insurance. He gave her the DPS contact number, instructing her to call exactly at 7 a.m. for reinstatement help. Warning: severe consequences for any future violations.
We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 24th, 2025, the officer conducted a motor vehicle check on the defendant's vehicle while traveling on the 7500 block of West 1960 road in Harris County, Texas. The officer observed the registration to be expired as of January 2024 and no valid financial responsibility on the vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle. The officer conducted a person check on the defendant and saw her driver's license was suspended as of February 1st, 2024, and she was identified with a Texas ID.
All right, Miss Orange, I'm gonna find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. I don't care what's going on in your life. If you want to drive, go get a license, get liability insurance. But if I find that you drive, it's going to go really, really wrong between us. Do you understand?
Yes.
I'm going to have you sign an affidavit. This is a promise that you're going to make to me that you're not going to drive. I don't care if there's a burning building with 50 kittens that need to be saved. Do not drive. Do you understand? I'm giving you now the number to the driver's license division to DPS. This is the number that you need to call to figure out what you need to do to get your license back. When you call them, call at 7 in the morning. Do not call at 8:01. Do not call at 9:50, 1:03. You'll never get through because the lines are so jam-packed. You need to call the minute the phone lines open up, which is at 7 in the morning. They can tell you what you need to do to get your license back. If you get it back and you show me that you also have insurance, I will take this restriction off of you. Trust me, do not drive. Do you understand?
Yes.
You need a lawyer to represent you in this case. Would you like me to give you a court-appointed lawyer?
Yeah.
Okay. I will give you one. I need you to fill out an application for me. I'm gonna have you swear to us that you're not gonna drive. After that, I'll get you to Victoria, sign a reset, and then we'll have you take a seat in the jury box where we'll find your lawyer. Okay? Please. You are Ms. Patterson?
Yes.
And you are charged with criminal trespass of a habitation or shelter. As such, it's kicked up to a Class A misdemeanor. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 24th, 2025, the officer was dispatched to an apartment regarding a family disturbance. The officer made contact with the complainant, and the complainant was in a former dating relationship with the defendant and stated the defendant had been banging on the door of her apartment since January 23rd, 2025. The defendant had not made any threats or said anything besides banging on the front door. The officer observed the defendant moving around the rear seats of the complainant's motor vehicle, and the complainant approached the vehicle and claimed ownership and identified the defendant as the person inside. The complainant stated she recently got the vehicle, had not let the defendant borrow the vehicle or use it in any manner. The complainant also stated she secured all the seats, and the defendant stated the motor vehicle was already unlocked and the officer did not observe any signs of forced entry. So in this case, the trespasses of the vehicle. And that is how the information is split as well, Your Honor.
I don't know if that counts as a habitation,
And Your
shelter, super fund,
Honor,
car.
as the information reflects, the charge is just criminal trespass with the vehicle being alleged to be the trespass. There's no mention of a
I
habitation.
get it, but you kicked it up. Like if it was a Class B, okay. But in this case, the intake made it a Class A by saying it's, typically this enhancement is reserved for a structure, right? Like a house, an apartment, a shelter. I don't know if a car counts. Let's look it up. Yep, it includes vehicle. Habitation means a structure or a vehicle that is adapted for the overnight accommodation of persons and includes A, each separately secured or occupied portion of the structure or vehicle, and each structure appertaining to or connected with the structure or vehicle. Vehicle includes any device in, on, or by which any person or property is or may be propelled, moved, or drawn in the normal course of commerce or transportation, except such devices as are classified as habitation. Okay, all right. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to go where they live. Do you understand? The complaining witness in this case.
That's where I live. And they here today.
This, I'm going to appoint you a lawyer today.
Okay.
We'll have you guys work out the kinks. The only thing I want is I don't want you to have contact with the complaining witness in this case. no weapons, and not to go where they live or where they work. Do you understand? Unless I know that they want to have contact with you. So we're going to find out. Have you done a rip?
No, Your Honor, we haven't had a chance to. We can reach out now, see.
So
She's
we're going to need a
here.
little bit of time.
She's
Here,
here.
Your Honor.
So let's do this. Let me appoint your lawyer now.
Okay.
She's back there in the head.
Okay.
We'll have you guys talk, but for the meantime, I'm going to have you sign a receipt, Victoria. We'll have you take your seat in the jury box. Okay? Please. Ms. Pena, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 24th, 2025, the officer observed the defendant's vehicle in front, following a vehicle very closely at the 2800 block of Center Street in Harris County, Texas. An NCIC search showed an unconfirmed insurance status with no match found within the last 45 days. The traffic stop was then conducted, and the officer made contact with the defendant, the driver of the vehicle, and the officer observed red bloodshot eyes, strong odor of an alcoholic beverage, and the defendant stated she got off work, smoked marijuana, and went to a local bar where she had 1 beer. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated her level of intoxication would rank 4 on a scale of 1 to 10, and the defendant was read the DIC, and she consented to breath. The results were 0.053 and 0.056. The defendant then refused a DRE evaluation, and a consensual blood draw was completed.
Okay. So how many other DWIs does she have?
It was just one prior in 2022, Your Honor.
NCIC?
I ran it, Your Honor. This only the one prior.
The other PCS that was right afterwards, right? Oh, so they were both, okay.
They were both dismissed, Your Honor.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. Oh, have you run her license?
It's eligible, Your Honor.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything, I'm going to revoke your bond, put you in jail. Do you understand? Do you need a lawyer today, ma'am? Okay, I'll have you fill out an application. I'll take a look at it and see whether you qualify, and I'll appoint your lawyer today. If you don't have a license, don't drive. If you don't have insurance, don't drive. Above all else, don't consume alcohol or illegal drugs. You understand? Okay, please.
Good morning. Good morning.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 25th, 2025, the officer arrived on scene and made contact with another officer who had been en route to a burglary and observed the defendant's vehicle traveling in the middle of a two-way road. That officer had pulled over to the right as far as possible, slowed down, and the defendant still struck the patrol vehicle on the front left side. The officer stated that the motor vehicle continued to drive, turned into an apartment complex, and the officer pulled up behind the vehicle as it was waiting for the gate to open. The defendant exited the vehicle, and the officer made contact with the defendant. The defendant stated he did not know who he had struck, and the officer observed red glossy eyes, slurred speech, a strong odor of an alcoholic beverage. Standard field sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant read the DIC and consented to breath. The results were 0.141 and 0.145.
Mr. Oriana, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, you will go to jail. No more PR bonds for you.
And there's no license on file, Your Honor.
Prior to the honest.
No prior, Your Honor.
Okay. If you do not have a Texas driver license and liability insurance, Mr. Oriana, you are not allowed to drive. You will be signing a promise with me today. I hope you take this seriously.
Defendant Oriana was charged with DWI after hitting a patrol car. The judge stressed immigration consequences, warning detention, and deportation if jailed. Oriana was ordered not to drive or drink, to undergo random testing, and to stay in contact with counsel. Failure to comply would result in immediate arrest.
Seriously. This is the only warning that you will get. I don't know what your immigration status in this country is, but if you're not in this country with permission and you go to jail for any kind of any kind of period of time, it's very possible that immigration finds you, puts a detainer on you, and you will be stuck in custody until this case is over with, and then you will be shipped off to immigration. Do you understand? Do not
Yes.
drive, do not consume alcohol or illegal drugs. Otherwise, it's not going to end well for
No
you.
le va a ir bien a usted.
Gracias.
Thank you.
Tell me, did you want to apply for a court appointed lawyer?
¿Quiere solicitar un abogado de planta?
Sí.
Yes.
All right, I will give you an
Está bien. Le voy a dar
application.
una aplicación.
I will take a look at it,
Entonces la
see
miro.
whether you
A
qualify
ver si
for,
usted califica para un abogado.
I'm gonna have you come up here, swear to us that you're not gonna drive. I will get you to Victoria where you will sign a reset. You will then get with Fatima for your bond conditions, and after that, we'll have you take a seat in the jury box, sir. Mr. Alfaro, you are charged with harassing communication. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On August 26, 2022, the officer was dispatched to a harassment call and met with the complainant, who explained she had broken up with the defendant on August 20th after dating 2.5 years. The defendant came to the complainant's parents' home early in the morning of August 21st and began knocking on the door and refused to leave. The defendant got into an altercation with the complainant's brother, and the complainant then went to work, where she received phone calls and text messages. The complainant responded in text asking for the defendant to stop contacting her. And over the next 2 days, the defendant continued to text the complainant asking to just talk. On August 24th, the complainant went to the defendant's apartment to retrieve her belongings, and upon returning to her parents' house, the complainant observed the defendant circle the area. On August 25th, the complainant's father observed the defendant parked down the street in a vehicle. 5 p.m. that day, the complainant's friend observed the defendant had been driving past the complainant's apartment, and the complainant observed the defendant driving around her parents' neighborhood and parked outside for a while before leaving. The defendant then attempted to contact the complainant by phone and text messages, as well as driving to the complainant's place of work, and contacted the complainant's work asking to speak with the complainant. The complainant stated she has received 50 calls and approximately 100 text messages, as well as 15 to 20 calls from some unknown number.
Alfaro, I'm gonna find that there's probable cause to go forward into your case. I'm ordering you as a condition of your bond not to have any contact with the complaining.
Defendant Alfal faced harassment charges after repeatedly contacting an ex despite warnings. The judge imposed a no contact and no weapons order, warning jail for violations. The defendant, age 25, was assigned a lawyer and told to sign bond conditions before leaving, ensuring he understood the serious consequences of further harassment.
Complaining witness in this case. Do you understand? I don't care what you're doing. I don't care where you're going. I don't care what color you are. If I find that you try to have any kind of contact, I'm going to put you in jail. Do you understand? How old are you, sir?
25.
Did you want to apply for an appointed lawyer, sir? Okay. Can you file the conditions, no contact and no weapons, please? I'm going to give you an application now. I'm going to have you sign a reset with Victoria, then we'll have you take a seat in the jury box. I'm going to find your lawyer. Do not leave until you sign our bond conditions. Do you understand? Okay, please.
So I'm one of your MAC attorneys today, Judge, and I have a couple clients, but Miss Patterson, she's
Yes.
struggling. It's a trespassing case,
Okay.
and it's a little weird, but I think you might have issued conditions for no contact at all.
Okay.
And we were going to ask if the state was in agreement to change that to no threatening, harassing, assaultive contact.
So my thing is that I always want to honor the wishes of the complaining witness. If they're okay with it, then I'm okay with it.
I spoke with the complainant and she's fine with them living together and still contact. It's just no threatening, harassing behavior.
Where is Miss Patterson? Come up, Miss Patterson. So. Got it, yeah. So I will amend your conditions to order you not to have any threatening or harassing contact. What you need to understand, what is threatening or harassing doesn't matter what you think. It's what she perceives. So is this threatening or harassing? It most certainly is, and it can land you in jail. So I don't know what kind of relationship you have, but if it's one that you're constantly butting heads, be careful because you're the one that's going to end up in jail if there's another fight and she comes up and she starts complaining. Do you understand?
Yes, sir.
Okay, it's done. All right, so you file it, we'll sign it, and then you guys are free to go. And one more thing, you must stay in touch with Mr. Landreneau.
Yes.
If he tells me he can't get a hold of you because you've gone AWOL, I'm going to issue a warrant for your arrest. Don't pick up a new case. Okay, good luck. Mr. Martinez, you were charged with evading arrest, theft, failure to identify oneself, driving while intoxicated, and you also have a felony theft of a firearm. What are we doing?
He is pleading guilty to DWI and evading, 30, credit for 23, and then they are going to dismiss the felony. That's why Herman's here. He's on the felony.
So, well, they're going to dismiss what the felony
Once
theft.
he pleads, they're going to dismiss the felony, yes.
So we're going forward on the DWI and the evading.
Yes, Your Honor, that is correct.
Mr. Martinez, you're charged with driving while intoxicated and evading arrest. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. On the evading arrest, you're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 30 days in jail with credit for the 23 days. He actually has 26 days credit.
It's 26 days on one and 23 on the other.
Okay. You need to understand that these charges will go on your record. The evading arrest is an enhanceable offense. If you ever run from the cops again, you will be charged with a felony offense. Do you understand?
Yes, sir.
The DWI is also going on in your record as well. So if you ever get pulled over by an officer, they're going to look up your record. They're going to see, man, this guy's got a lot of baggage on his record. If they smell alcohol or if they smell dope on you, what do you think they're going to do?
I already know it. They're gonna pick me up.
From now on, you are facing a minimum of 90 days in jail. Any new cases that you pick up. Do you understand?
Yes, sir.
Even if you've had a sip of alcohol, I wouldn't get into a car because you were taking a humongous risk.
Sir.
Do you understand?
Or drugs.
Or prescription
Anything.
drugs.
What I informed Mr. Martinez,
Okay,
just
any
for your
drugs, yes, sir.
purposes, even though
Or
he's
about
getting his theft dismissed, it's gonna be based on a conviction on another case, so it's not expungable. The statute does not allow that case to be expunged,
Which one?
the theft of a firearm.
Do you understand that, right?
Yes, sir.
I don't think any of the cases. Or wait a second, hold on a second.
Separate, the ones that are separate transactions, Your Honor.
All
3 are out of the same
Okay,
transaction.
well then, yeah.
Yeah, so the evading, theft, failure to ID, all those are based out of the same transaction because none of the cases can be expunged. So the ones that are dismissed, they're going to stay on there, they'll be dismissed, but the others will reflect as a conviction on your record. That's what I'm saying. From now on, it's a minimum of 90 days in jail for anything that you pick up here in misdemeanor court. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, you can never change this or undo this. Do you understand?
Yes, sir.
This is what you want to do. How do you plead to both of the cases, guilty or not guilty?
Good, sir.
I want you to understand one more thing, Mr. Martinez, that DWI is big business in Harris County. There's a $3,000 surcharge that normally would apply to this. I'm not going to stick it on you now because it's a first offense, but on a second DWI, you're looking at a $6,000 surcharge that you get hit on a second DWI. Get a clue, take an Uber. Do you understand?
Yes, sir.
I'm going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir.
Thank you, Your Honor.
Thank you, sir.